Contract Act, Section 6, Revocation of Proposal How made. Section 6 of the Indian Contract Act, 1872 specifies the circumstances in which a proposal is revoked and explains the different modes by which an offer legally comes to an end. It ensures that an offer does not remain open indefinitely by clearly defining the events that terminate it, thereby promoting certainty and reducing disputes in contractual negotiations. 1. Purpose of Section 6. The primary purpose of Section 6 is to prescribe the legally recognized methods by which a proposal may be revoked before a contract is formed. Once a proposal is validly revoked, it can no longer be accepted, ensuring certainty and fairness in contractual negotiations. 2. Revocation by notice of revocation. Under Section 6, 1. A proposal is revoked when the proposer communicates a notice of revocation to the other party before the proposal has been validly accepted. Once the notice of revocation reaches the offeree before acceptance is complete against the proposer, the offer comes to an end and can no longer be accepted. 3. Importance of communication of revocation. Merely deciding to withdraw an offer is not sufficient, as the proposer must communicate the intention to revoke to the person to whom the proposal was made. This ensures that the acceptor knows the offer is no longer open, making proper communication essential for a valid revocation. 4. Revocation by lapse of prescribed time. Section 6, 2, provides that a proposal is revoked if the time specified for its acceptance expires without any communication of acceptance. If acceptance is not communicated within the prescribed period, the proposal automatically lapses, and no separate notice of revocation is required. 5. Revocation by lapse of reasonable time. Where a proposal does not specify a time for acceptance, it is revoked after the lapse of a reasonable time if no acceptance is communicated. What amounts to a reasonable time depends on the facts of each case, including the nature of the transaction, market conditions, and the conduct of the parties. 6. Revocation due to failure of a condition precedent. Section 6, 3, provides that a proposal is revoked if the acceptor fails to fulfill a condition precedent required for its acceptance, preventing the formation of a binding contract. 7. Meaning and importance of conditions precedent. Conditions precedent protect the proposer by requiring specified conditions, such as providing documents, approvals, or security, to be fulfilled before acceptance, failing which the proposal stands revoked under Section 6. 8. Revocation by death of the proposer. Section 6, 4, provides that a proposal is revoked by the death of the proposer if the acceptor becomes aware of the death before communicating acceptance, as the offer cannot continue without the proposer's intention. 9. Revocation by insanity of the proposer. A proposal is revoked if the proposer becomes insane and the acceptor learns of the insanity before communicating acceptance, as the proposer loses the legal capacity to enter into a valid contract. 10. Importance of knowledge in cases of death or insanity. Section 6 provides that the death or insanity of the proposer revokes the proposal only if the acceptor has knowledge of it before communicating acceptance, thereby protecting an innocent acceptor who accepts the proposal without such knowledge. For more details, contact us.